Care and protection hearings. What are they and what are they for? Well, a care and protection hearing is to hear the application Oranga Tamariki have made under Section 68, which is care and protection. This is normally alongside of has normally been done alongside of the Section 78(1) interim custody order that they have applied for until such time as the court has the hearing. Once you're at the hearing, normally the order they will apply for is an S101 or full custody for them. They will normally also apply for a order under Section 110, which is guardianship. It might be additional, it might be sole, it might be, those types of things. Now, if they're successful in obtaining an S101, which 90% of the time, 99% of the time really, they are successful in doing because of the manipulation of the system. What I'm wanting everyone to know in regards to this particular video is this. As far as I'm aware of from all the people that I've given suggestions to, everybody believes that an S101 is home for life. Okay. They believe that it's a permanent placement. And I want to be able to set the record straight and state that under the Act, there is no such thing as permanency. So when a parent is led to believe by more than likely their lawyer that, okay, they've got an S101, there's nothing we can do in regards to it, you won't be getting your child back. All I can say to that from my own personal view of looking at legislation and all of the stuff through the justice system, that is completely incorrect and you are completely being misinformed. If you take a look at Section 101, there is nothing at all about permanency within that section. This is why they have Section 125 of the Oranga Tamariki Act for the parent to be able to apply to discharge those orders. Now, just like when you're dealing with the Care of Children Act, if there's a material change in circumstances, then you are able to go back to court on it, on a discharge or variation. An example of that is this. If your child has been placed under S101 and your child has been seriously hurt, then that is a reason for a serious material change in circumstances and a reason to apply back to the court in regards to the fact of returning your child. Now, don't be led astray by the lawyers who will turn around and say to you, we can't do anything within a 2-year period because they were granted a final order. That is correct. However, it is subject to the material change in circumstance, which it quite clearly says under 206A of their Act, which is you have to apply for leave to be able to go back to court on it. But that leave is subject to material change. And so if you have a material change in circumstances, then you are able to apply within that 2 years. If the material change of circumstances happens 2 days after you've been to court and they've been given the orders, you still have the ability to reapply back to the court to have those orders discharged. Again, I will say most lawyers are going to tell you opposite. My advice to you is don't take what I'm saying for granted. Look at Section 206A, subsection 3, and you will see it for yourself. Okay, if you're applying to discharge or vary the order, there must be a significant material change in the circumstances. If there is, the leave is not required. It's as simple as that. We are all led to believe by the system that we cannot apply to get the children back for a 2-year period. Incorrect. It is within legislation. So once again, guys, thanks for watching. I hope you're finding these videos informative. And I will keep putting them out as I think of the things that people have asked me over time, which have helped to empower them. Thank you again. Bye.